A dramatic shift in U.S. immigration policy is now facing its first courtroom showdown. The Trump administration has slapped a one-time $100,000 fee on every new H-1B visa, an employment program companies rely on to bring in highly skilled foreign talent. Within days, a broad coalition sued to stop it, setting up a high-stakes fight over presidential power and America's ability to compete for global expertise. First, a quick primer on the H-1B. For decades, it has let U.S. employers temporarily hire workers in specialized fields that generally require at least a bachelor's degree: software engineering, nursing, university research, and more. Before this proclamation, employers paid application costs of just a few $1,000s. Tech giants like Amazon and Google, regional hospitals, and state universities all tap the program when they can't find enough qualified U.S. workers. That changed on September 19, 2025, when President Trump signed a proclamation imposing the new six-figure fee. The administration framed it as an incentive for businesses to hire American first. Commerce Secretary Howard Lutnick called the H-1B the most abused visa, arguing the steep price will deter companies from using cheaper foreign labor. The order took effect with only 36 hours' notice, leaving employers and foreign workers scrambling for answers. Almost immediately, the policy landed in federal court. In the Northern District of California, labor unions such as the United Auto Workers, the American Association of University Professors, a nurse recruitment agency, and several religious organizations filed the first lawsuit seeking an emergency block on the fee. Their case rests on two main arguments: constitutional authority. They say the president cannot levy what amounts to a new tax without congressional approval. The power of the purse belongs to Congress. Statutory procedure. They allege the proclamation sidesteps the Immigration and Nationality Act and the federal rulemaking process, both of which require public notice and comment before such a sweeping change. The plaintiffs warn of far-reaching fallout. Hospitals already struggling with staffing could lose foreign doctors and nurses. Universities might forego hiring top researchers, slowing innovation. Smaller tech firms could push jobs overseas rather than pay the fee, hollowing out domestic growth. They also criticize a national interest exemption in the order, arguing it invites selective enforcement and corruption, essentially a pay-to-play system favoring those with political pull. Corporate America is equally alarmed. Business associations spanning technology, manufacturing, retail, and agriculture argue the fee will choke their talent pipeline and hit mid-size and startup companies hardest. While giants may swallow the cost, smaller firms say they'll be priced out of the global talent market. Sector by sector, the impact looks stark. Healthcare. Rural and underserved hospitals rely on foreign physicians and nurses. The fee could deepen shortages and lengthen patient times. Higher education. Universities could face millions in new annual expenses, threatening research grants and teaching capacity. Technology and engineering. Big players may absorb the cost, but younger companies, often the source of cutting-edge innovation, may relocate R&D abroad. What happens next? The plaintiffs have asked the court for an immediate injunction that would freeze the fee while the case proceeds. Whatever the judge decides, appeals are almost certain. The battle could climb all the way to the Supreme Court, becoming a landmark test of executive authority in immigration and economic policy. For employers and foreign professionals, the stakes are immediate and personal. Stalled hiring plans, delayed relocations, and career paths thrown into limbo. For the country, the broader question looms: can the U.S. restrict a key visa program without crippling its own competitiveness? As the legal fight unfolds, one thing is clear: This single line in a presidential proclamation has ignited a clash between two core American impulses: protecting domestic jobs and welcoming global talent. The courtroom drama now underway will determine which vision prevails and how high the price of entry to the United States will ultimately be.
Welcome to AI TV News. The U.S. Treasury Department is weighing a $1 commemorative coin featuring President Donald Trump, and Treasurer Brandon Beach confirms the draft designs circulating online are authentic. The proposal drops into a combustible mix of history, law, and politics, just as the nation prepares for the 250th anniversary of independence in 2026. First, the why. Congress gave the Treasury Secretary authority to issue special dollar coins for the semi-quincentennial under the 2020 Circulating Collectible Coin Redesign Act, legislation signed by then-President Trump. The law calls for designs emblematic of the United States semi-quincentennial, leaving wide creative latitude. Now, the what. Beach posted two preliminary images on X. A profile of Trump under the word liberty, with the dual dates 1776 to 2026. Trump raising a clenched fist before an American flag, mirroring his reaction after the July 2024 assassination attempt, alongside the phrase, "Fight, fight, fight." A Treasury spokesperson stresses no final decision has been made, but says the draft reflects the enduring spirit of our country and democracy. Asked whether the president has seen the mock-up, White House spokeswoman Caroline Leavitt replied, "I'm sure he'll love it." That optimism collides with a 159-year-old obstacle. Since 1866, U.S. law has effectively barred living people from appearing on currency, a safeguard meant to avoid any hint of monarchy. Only once has a sitting president slipped through. Calvin Coolidge shared the 1926 sesquicentennial half-dollar with the Liberty Bell. Could the Trump coin follow the Coolidge precedent? Legal analysts are dissecting the 2020 semi-quincentennial statute, which reads, "No head and shoulders portrait or bust of any person, living or dead, and no portrait of a living person may be included on the reverse of any coin." Supporters argue the reverse image is a full-body action shot, not a portrait, and therefore might skirt the letter of the law. Critics counter that the spirit of the restriction is unmistakable. For additional context, the 1976 bicentennial dollar was chosen through a public design competition and featured the Liberty Bell and the moon, while the Statue of Liberty commemorative of 1986 remains the best-selling U.S. collector coin ever. Both honored national symbols, not living leaders, underscoring how unusual the current proposal is. Complicating matters, the debate unfolds during a federal government shutdown that began on October 1, 2025. Treasury officials say further guidance on the coin will have to wait until normal operations resume. To recap, draft designs featuring President Trump have been verified by the U.S. Treasurer. Authority for a 2026 commemorative coin exists under a 2020 bipartisan law. A long-standing ban on living figures on currency looms large, though historical and legal loopholes are being explored. Final approval is on hold amid the ongoing government shutdown. Whether the Trump dollar becomes legal tender or collector's lore, the conversation it has sparked about patriotism, precedent, and power may prove just as enduring as the coin itself.
In Des Moines, Iowa, the city's largest school district is scrambling to explain how its superintendent ended up in federal custody and why no one caught the warning signs sooner. Now Des Moines Public Schools is suing the search firm it paid to find that leader, saying the company's failures cost taxpayers money and tarnished the district's reputation. The crisis unfolded on September 26, 2025, when U.S. Immigration and Customs Enforcement agents arrested Dr. Ian Roberts during a traffic stop. Authorities say Roberts first identified himself, then sped off, abandoned his car, and tried to hide in nearby brush. Inside the vehicle, agents reported finding a loaded handgun, a hunting knife, and nearly $3,000 in cash. Within days, the fallout was swift. Roberts was placed on leave. His state administrator license was revoked, and he resigned on September 30th. On October 2nd, he was indicted on federal charges of being an undocumented immigrant in possession of firearms. Feeling blindsided, the school board voted on October 3rd to sue JG Consulting, the Texas-based firm hired in 2022 to lead the superintendent search. The lawsuit accuses the company of breach of contract and negligence, saying that Roberts should never have been presented as a finalist. The district wants its money back and damages for reputational harm. Under the contract, JG Consulting was supposed to verify resumes, run criminal and credit checks, and thoroughly vet references. District officials say none of those steps flagged the red flags federal agents later revealed. Those red flags are extensive. The Department of Homeland Security says Roberts, a native of Guyana, has been in the United States illegally since his work authorization lapsed in December 2020. An immigration judge ordered his removal in May 2024, information the district says it never received. Roberts' current attorney claims his client believed a previous lawyer had resolved the case. Roberts also carries a criminal history. Records show narcotics and weapons charges in New York in 1996, weapons charges in 2020, and a 2022 conviction in Pennsylvania for unlawful possession of a loaded firearm. The district admits it knew about the 2022 incident, which Roberts had characterized as a minor hunting citation. Then come the questions about his resume. In application materials, Roberts listed a doctorate from Morgan State University, an institution that confirms he never completed the degree. He also claimed to be an incoming MBA candidate at MIT, but the school has no record of him. He does hold a doctorate from Trident University International, an online for-profit institution. The board says the search firm noted the incomplete Morgan State degree, yet still advanced him. So how did someone with immigration issues, a criminal background, and academic discrepancies end up in charge of 30,000 students? School board members say they relied on standard safeguards. When hired, Roberts signed a federal I-9 form swearing he was a U.S. citizen and provided a Social Security card and driver's license as proof. A separate third-party background check was conducted, and nothing disqualifying surfaced. Board Chair Jackie Norris now calls the district a victim of deception, but critics argue basic due diligence should have revealed the contradictions. The Department of Homeland Security frames the ordeal as a public safety failure, pointing to Roberts' criminal history and his access to children. In Des Moines, the community reaction has been intense. Students have staged walkouts, and families are grappling with how the charismatic educator they knew could be the same man federal agents describe. As the lawsuit moves forward, two core questions remain. First, was Roberts a master of deception, skilled enough to fool multiple layers of screening? Second, did the consulting firm, and by extension the district, skip steps that would have protected students and taxpayers? The answers will determine not only who pays for the legal fallout, but also how much trust the district can regain. For now, Des Moines Public Schools faces the costly task of repairing its image, hiring an interim leader, and proving to families that every future hire will be vetted with far greater scrutiny.